Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Zeni versus Anderson. This case was heard in the Supreme Court of Michigan in the year of 1976. Let's go ahead and jump into the facts of the case. The plaintiff, Zeni, was a 56-year-old woman. She was a nurse at Northern Michigan University Hospital System. Anderson, the defendant, was a young student attending Northern Michigan University. Anderson was on her way to school in a vehicle, and when Anderson was on her way to school, her vehicle struck Zeni. Zeni was walking towards work. She was walking rather than driving, and Zeni was walking on the road instead of the sidewalk. Like I said, it was a cold, snowy morning. Zeni felt that it was easier to walk on the road than the sidewalk. Anderson didn't see her. Anderson's vehicle struck Zeni, and Zeni brought suit, claiming that Anderson was negligent in the way that she drove her vehicle. So the court has to wrestle with an argument put forth by the defendant and the defendant's attorney that Zeni was contributory negligent in this situation because Zeni was walking on a road. The defendant's attorney cites a statute that prohibits anyone from walking on a roadway and claims that because Zeni was violating this statute, she is just therefore she's contributory negligent. So the defendant's attorney is arguing for negligence per se interpretation of the statutory breach, meaning that he's arguing that because she breached the statute, just in fact, then she was contributory negligent. So that's what the defendant's attorney is arguing. He's trying to, advocate for his client. I think it was a wise way to do so. Ultimately, the Supreme Court of Michigan says there's three types, and they discuss the three different types of ways to handle statutory breach. The first one being negligence per se, which means that if someone breaches a statute, just they're automatically negligent. The next would be negligence is a rebuttable presumption. So it's a presumption of negligence if you breach a statute, and then someone can rebut that. So a defendant can rebut it. And then the third would be evidence of a statutory breach is just evidence. It doesn't really, put any weight on the jury as far as a presumption or as far as a determination of negligence for that statutory breach. So ultimately, the court says we're going to adopt the middle ground view of statutory breach, which is that if someone breaches a statute, it's presumed that they're negligent, but there's an opportunity for that person to rebut the presumption. So Zeni is put in an interesting situation where she has to rebut a presumption of contributory negligence. So that's what she argues, and the way she argues that is by saying that following the law in her situation actually would have been more dangerous to her than breaking the law. So that's the way she tries to rebut it. She says that if she was walking on the sidewalk and she invokes some testimony from a security guard at the university, that she'd be more likely to slip and fall and injure herself than if she was walking on the road. And I think that if you live in a snowy area like I do, you can see how this is possible, right? Roads are much more often plowed, much more often salted than sidewalks, right? The city, universities, public institutions make sure roads are taken care of before they make sure sidewalks are taken care of. So in this case, where the road was taken care of, it would have been safer for Zeni to walk there because it would have been less likely that she was going to fall. So that's what Zeni argues. And the court likes her rebuttal of her presumption of contributory negligence, and they rule in favor of Zeni, saying that she was not contributory negligent just because she breached the statute, because she rebutted that presumption by saying that it was actually more safe for her to violate the statute of not walking on the road than it would be for her to walk on the sidewalk. So very good lawyering on behalf of Zeni, drawing a distinction and providing a sufficient rebuttal of the presumption of contributory negligence. So that's the case, and that's what you need to know for a case brief. Let's just jump into a little bit of a discussion about this, and I just want to discuss the different treatments of a statutory breach, and this being the middle ground. It's a rebuttable presumption of negligence if you breach the statute. That's the middle ground. And I think that it makes a lot more sense than just saying if you breach a statute, you're just going to be held negligent, right? And that's negligence per se. And this middle ground that the court uses in this ruling is a lot more sensical than saying that if you breach a statute, you're automatically negligent, right? Like, how often are you jaywalking, or how often are you, maybe breaching a statute that you're not completely aware of, or you have no reason to be aware of it? And should we just hold anyone, automatically liable for any type of negligence because they breached that statute. And that's what the negligence per se view would do. This middle ground allows at least the defendant, the person who is being charged with some type of negligence because of a statutory breach, it allows them the opportunity to rebut that presumption and say that there's good reason why I was breaking that statute. And I think that we can all put ourselves in the shoes of Zeni, where we would say, yeah, we might be violating a small statute, maybe nothing huge, but we might be violating a small statute, but we have good reason to do it. And the court allows a defendant the opportunity to rebut the presumption. And I think that this nice middle ground is a good way to go. And so I just want to commend the Supreme Court of Michigan. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a great rest of your day. Bye-bye.